Well, Public Protector Advocate Busisiwe Mkhwebane is under tremendous pressure following a Concourt ruling judgment, or rather judgment this week, that she had been dishonest and that she had lied. Mkhwebane also appeared in court defending Pravin Gordhan's application for an interdict against her findings on him when he was a finance minister. And soon she will also face a review of her report on President Cyril Ramaphosa. With all this happening around her, the ANC NEC Lekgotla this weekend may likely discuss her position. Advocate Mahlodi Muofhe wrote an opinion piece on the Public Protector this week, and the Advocate now joins us in studio. Very good evening to you, Advocate, and thank you very much for your time this evening.
Good evening.
Now, just going back on your piece, you say essentially that the Public Protector needs to learn from the Constitutional Court finding. What did you mean by that?
Well, what I meant by that is that that office is governed by law, by the Constitution, by the Public Protector Act. So anybody occupying that office must understand what is entailed in these acts which enable her to work or him to work. Now, this Concourt decision, which basically said she's got to pay 15% of the cost in the litigation against the Reserve Bank and Absa Bangkok, it's something which anyone affected by such a Concourt cost order decision should take a seat back and look at how he or she operates, because it's not common that the apex court can come to such a drastic decision.
Now, the Apex Court has dismissed the SARB's application for that order to find Mkhwebane, that she has abused her office while still under investigation. What's the comment on that? And how essentially would this affect her?
Well, basically, more than anything else, what broadly the court is saying is that it is important that when you are occupying that position, you have, before you release any report, to quality check that report, to make sure that that report will pass the constitutional muster, instead of just releasing it. Because in the process of releasing reports, the likelihood of impacting negatively rights of those who are affected by that review, your report, is high. So the Concourt is basically saying we're all equal before the law, and it's important to apply the law properly and not abuse that process, which is what basically the majority decision said in that case.
Now, in terms of the processes and the duties that she upholds as a public protector, you also went on to say that she owes us fiduciary duties to strengthen our economy.
Well, basically, I said Chapter 9 institutions, when we brought them into being, the idea, and it's a noble one, that Chapter 9 institutions should assist us to strengthen our constitutional democracy by ensuring that we adhere to what we set ourselves to achieve as a country when we wrote the Constitution, when we attained our democracy. So they are there to oversee that whatever we agreed to, we stick to what we agreed to. They are there to ensure that, the money which taxpayers pay must be used properly to ensure that services to the majority of South Africans reach them without any cent being stolen from them.
Now, some people are calling for her axing. We've also heard a word from the Helen Suzman Foundation. They've also written to Parliament with regards to that. Is this justifiable?
Well, those who are calling for axing, they probably must have applied their minds and probably reached to that conclusion. I haven't really gotten to that stage. And the reason why I haven't really gotten to that stage is that much as the majority decision went against her in terms of this matter, the minority decision as well should be persuasive enough for us when taking decisions to understand that that minority decision by our Chief Justice is basically saying, you know, we shouldn't just sledge those who are affected by some of these decisions with a hammer. It's important to understand that when we do take decisions, we should balance the decisions that we take. So, and I would imagine that probably that minority decision had that in mind, that there are possibilities that you know, there may be others wanting to call for the removal of the person. Even, as I say, you know, when issuing these reports, it's important for the incumbent to make sure that they are properly quality checked. Even those who want to call for axing, you know, I would imagine that they would have taken everything into account and come to a conclusion that the incumbent is not fit and proper to occupy this position. But I think it's important to also read the minority judgment in that case to balance the equation.
You know, in the past couple of years, there'd have been a different fight in the role that the public protector had played in the protection of providing information in the role in investigating such instances. Has this now, you know, put some sort of dark cloud on how the public protector and the services is viewed?
Well, I think majority of South Africans are probably looking at the decisions of the incumbent, not necessarily questioning the institution itself. The institution itself is much needed. And I think we all agree that we have to have the Public Protector Office. But it is a bit unfortunate that, you know, in some cases, critical cases, the courts of our land have found that she hasn't really applied the law properly or her mind properly. And the courts are there also to guard the interests of all of us. So it's important that we look at it from that point and distinguish between the person and the institution. The institution is critical to ensure that our democracy continues to breathe democracy into the lives of South Africans.
Well, thank you very much for your time this evening. That was human rights lawyer advocate Mahlodi Muofhe just taking us through the public protector woes in the week that was. We're going to take a short break. Do stay tuned to Watching the Full.